So good morning, everyone. Is everyone having a good day? I'll wave to you. You don't have to answer, but if you wanna unmute your microphone, I do welcome participation in this seminar. Today's topic is electronic signatures in real estate transactions, and I do have to speak about the gorilla or the elephant in the room, and I want to talk a little bit about the pandemic at the end. So before I start, I do want to say that real estate is considered an essential service. As lawyers and as brokers, we're all still working. Obviously, as an agent, you have to take additional precautions to keep yourselves and your clients safe. I do understand that the way you're showing houses has changed, but I do see business continuing. It's not as much as we normally expect at this time of the year, which we had started off with a very hot spring market, and we were talking about multiple offers and multiple representation a few weeks ago. Although I do still see some multiple offers, it's mostly restricted to condominiums. Right now, you have to think about how you can keep in touch with your clients and get them ready to make a move or to buy and sell real estate when things get better. And things will get better for all of us once the numbers get better and the curve flattens. So first I'm going to talk about electronic signatures, and at the end I'm going to talk about the 4 most common pandemic questions that I'm dealing with on a daily basis. And I do want you to feel free to interrupt me. My name is John Poletes. I'm a real estate lawyer. I've been practicing real estate since 2004. Probably in 2003 and 2004, you remember that we had SARS, and that's around the time that I started. Prior to coming into the real estate business, I was a real estate broker for over 20 years, and I basically grew up in the real estate business. So my studies have been in real estate at York University. I've been a broker manager. I've taught for REIA, and currently I teach for the Real Estate Institute of Canada. So basically, this is what I want to cover today. I want to give you a little bit of an intro to the legislative background. I want to talk about statute of frauds, the E-Commerce Act, how reliable e-signatures are, PIPEDA, rules of evidence under the Canada Evidence Act and the Ontario Evidence Act, and secure electronic transaction regulations. And I'm going to mention some e-signature technology providers at the very end. So this is a very common issue that I see with electronic signatures. We have a buyer who has used Adobe Photoshop and cut and paste the signature onto the APS. The seller has accepted it as an electronic signature using a service provider from offshore. So imagine your seller is in China or Europe, and they're using an electronic service provider similar to DocuSign offshore. And your buyer has just pasted an image of their signature on the deal. The seller's lawyer asks you for original documents or for the documents to be re-executed with ink signatures. The buyer's lawyer says, don't worry about it, it's a deal. You act for the buyer. Who is correct? Is this a problem for you? Have you fulfilled your obligations under REBA? So what does REBA say? RICO's position under Code of Ethics is that you're to use your best efforts to prevent fraud, misrepresentation, or error or any unethical practice in respect to a trade in real estate. Agents must ensure that technology they choose for electronic signatures must provide secure authentication and prevent unauthorized use. The agent must be able to confirm that the signature is from the person it's supposed to be. How do you carry out your own due diligence? Generally, I say consult with your broker of record, understand the implications of the technology that we're using, keep up with the updates, and use a well-recognized and legitimate software that is reputable and has licenses. So that's a big mouthful. How do we do all these things? question yourself as to where is the head office of the company and where is their server located. So if they're both in Ontario, you're probably on a good track. The problem with having an e-signature provider who's in Europe or China is the jurisdiction and the record keeping and different privacy legislation. So the problem is how are you going to have access to the proof that you need in case there ever was a dispute as to if the seller had signed. You're acting for the buyer, remember that. This is how e-signature started. In 1999, we had a Uniform Electronic Commerce Act that was passed, and this is the background legislation for all electronic commerce. It's based on a United Nations law that was adopted in 1996, and Ontario adopted its own Electronic Commerce Act in the year 2000, and it applies to most electronic transactions, or it did apply other than real estate. Real estate was a specific exception, and the reason we had this exception was the statute of frauds, and historically agreements of purchase and sale and lease for more than 3 years had to be in writing. That's the statute of frauds, and that's a very old legislation. This changed in 2015 when the act was amended and removed real estate transaction exception. So since 2015, the e-commerce act applies to real estate transactions. So I'm sure all of you have done real estate using electronic signatures up to now. This is what the statute of fraud says. The main statute requires real estate transactions to be in writing. No interest in land can be made or created without a written and signed agreement between the parties, or some memorandum or note thereof. No action can be brought in court without a memorandum or note. A written contract meets the requirement. However, there's no requirement that the memorandum has to be on a particular form. Courts have found that written proof of oral agreements can be in an electronic form and even exchange of emails. Courts have stated that a plaintiff may sue upon a contract that requires to be in writing, even though he has not signed it, providing there's some memorandum to the contract. I'd like to give you an example of what happened to one of my clients. One of my clients was purchasing a restaurant and a building. And my client and the seller decided that they were going to exchange some money without any contract, without any paperwork at all. So the buyer gave $100,000 to the seller without any paperwork. The only paperwork that they had was the liquor license transfer for the restaurant, plus their verbal understanding. Apparently, the seller changed their mind and they claimed statute of frauds, that there's no contract and there's nothing to support the transaction. The fact that there was a liquor license transfer was enough for my client to sue the seller and force the transaction to close. And the reality is there was enough evidence to support what he was claiming to have been a verbal agreement, and it did kind of fulfill the statute of frauds. So basically, the identity of the parties was dealt with. The property was mentioned. There was no other reason to have a liquor license transfer other than the sale in that case. The price was something that they had verbally determined, and it wasn't in dispute, and there wasn't intent to sell. So basically, that created enough evidence. So you have to be careful when you make agreements. Don't think just because you haven't filled it out on an ARIA form that you can walk away. There's also a court case here where there's an unsigned offer with part performance, Erie Sand and Gravel. Here the court decided the offer was signed only by the offeror and was not signed by the seller on all these essential terms. But there was part performance, and because there was part performance, it may have been enforceable. As a result of this case, agreements of purchase and sale which do not satisfy the written requirements and do have part performance are likely to satisfy the statute of frauds in courts. So this is the Electronic Commerce Act. Documents that create an interest in land now exist electronically, and this is the statutory confirmation of the statute of fraud. It means that the essential terms of a real estate contract can be signed electronically. The Act does not change the requirements for establishing enforceable contracts. You still need a signature. I'm not saying that you don't need a signature, you still need something. And there are what are called functional equivalency rules. So what is an electronic signature? Electronic could be a recorded, transmitted, or stored digital signature in the form of electronic or magnetic or optical means. This is a definition from the Act. It could be done using an agent through a computer program, or it could be basically any electronic information a person adopts to resemble their signature. So you can pick a PDF or a signature block and attach it, and that is an electronic signature. So the very first situation that we talked about fulfills the electronic signature. So even though the seller in that case was from out of country, although we're missing the evidentiary requirement of how are we going to prove it's him, that would be an enforceable contract. The buyer signed with cut and paste, that's also an enforceable contract. The definition of an electronic signature is very broad, but it can be anything from someone typing their signature and saying, this is my signature, I intend to be bound, or they can use a touchpad or an iPad, or they can attach a PDF signature or a signature block pasted onto a document. Copying or scanning an original ink signature is also allowed. Any sort of electronic technology is allowed to indicate a signature has been made. Obviously, I think the best thing to have is some kind of an image or digital certificate that accompanies the signature that authenticates your electronic signature. But the Electronic Commerce Act is so broad that it allows almost anything to be an electronic signature. So these are the important provisions of the Electronic Signature Commerce Act. No person is required to use an electronic signature. So what if I don't want to use an electronic signature? If I'm a seller and I say I only want a written signature, what does that mean to your buyer? What that means is that the seller is going to demand an electronic signature, a regular signature, and that's his choice. He can do that by withholding signing himself. But generally speaking, this is not in the interest of most sellers. If the buyer has signed electronically and they intend to be bound, there's no reason why the seller shouldn't also be able to sign electronically. To satisfy the written legal requirement of electronic signatures, the document that's signed has to be acceptable and usable for subsequent reference. So once you have an electronic signature on your agreement, you have to be able to store it and recover it whenever you need it. It has to be capable of being retained by the other person as well as other parties. If the document is not capable of being retained, that creates a problem. So Snapchat doesn't work for electronic signatures. The Act also talks about the reliability of the documents. And basically, the electronic signature has to be reliable for the purpose of identifying the parties. And it has to be associated with the document that we're talking about. Up to now, I haven't heard of any problems with electronic signatures. The main problem that I hear, and if anyone wants to comment on that, is sometimes people will sign and not realize that they've also released the document and then they change their mind about signing. So if you accept the document and then you want to go back and negotiate it, you have to make sure you haven't released it. If you've released it, the other side may receive an accepted agreement that you may not have intended to release to them, and you've communicated your acceptance of an offer. So how reliable are electronic signatures? So basically, in Ontario, the province has left it up to the person relying on the electronic signature to determine if they're sufficient enough and reliable in the light of all the circumstances. It's up to us to have the right evidence and have the documents that we've signed accessible to all parties after the agreement is made. Other legal provisions. So other legal provisions that we look at is what courts will say in the event of a legal dispute. We have to consider if there's any legislative provisions that would prevent us from using an electronic signature. The Canada Evidence Act provides some proof of authenticity of an electronic signature. Basically, as an agent, you have to be prepared to give some testimony as to how the signature was prepared, how the document was prepared, and how each of the parties signed electronically. To comply with PIPEDA rules and secure electronic signature regulations, should be a list of requirements for electronic signatures that must be satisfied. So this is the list of requirements. So basically, the electronic signature must be unique to the person using it. The person using it must have control of the technology. The technology must be used, must identify the person using the e-signature, and the e-signature should be linked to an electronic document. This is a process that a lot of the software that people are using does for you automatically, so you don't have to think about it. And obviously, you all know about DocuSign and AuthentiSign. I'm sure there's quite a few other softwares. They're designed to fulfill these requirements. The storage of the data should be in Ontario because that's the jurisdiction that we're in. We don't want to have another jurisdiction storing the data. And if you have the data stored in the United States, it's also subject to the United States rules and Homeland Security. So they will have an open window into what's going on in your transaction. These are the rules of evidence for proving an electronic signature. Any person seeking to admit an electronic document as evidence has the burden of proving its authenticity. So if I was a seller, how do I prove the authenticity of the buyer's signature? If the buyer says someone else put my signature there, if it was only a cut and paste, that would be a little harder to prove because we don't have, even though it's a legitimate electronic signature, I don't have a third-party authenticator other than the witness or real estate agent who was involved in the transaction. I believe that would be answered on a balance of the probabilities, and it would be one extra step in a trial if someone was claiming that as a defense. So you never want to go there, although I do see electronic signatures being used as cut and paste or a finger tracing of a signature. Basically, this is a secure electronic signature regulations, and they're talking about the application, a private encryption key. I think that's a little technical for now. I would like to go on because I do want to spend some time at the end talking about COVID. I don't want to miss the time I have for COVID, but these are the main e-technology, e-signature providers. So DocuSign, AuthentiSign, and Next One. Does anyone use one of those signature providers, e-signature providers? One of them is offered to you for free. Which one is that? Anyone unmuted? No? Basically, all of these e-signature providers fulfill the electronic signature regulations. I would suggest you stick to one of the main providers. If you don't have them set up, you can also do cut and paste and someone signing. But in the event there is a dispute as to how many, as to the authenticity of the signature, then you might run into trouble. So basically, does the Act change anything in creating legally enforceable documents? I don't think so. I think that offer an acceptance, whether it's electronic or an in-person signing, is a functional equivalent, and it's up to the users to determine if they're satisfied with the reliability and the standards of the electronic document that they're using. The authenticity of electronic documents still has to be proven under the Canada Evidence Act, which has more stringent requirements than those set up by the parties. Generally speaking, if someone's given a deposit, it's pretty hard to back out of the signature. So now let's talk about what I really wanted to talk about today. So today I wanted to also talk to you about some pandemic stories. So basically for e-signatures, I would say that try to use DocuSign or AuthentiSign, but don't shy away if someone wants to cut and paste. Your objective is to make a deal, and you have to rely on the document that's put before you in making the deal. I don't know of anyone who's ever challenged an electronic signature up to now. So COVID. COVID is an issue now that is coming up daily in our lives. I think that the news just repeats the word COVID continuously. My law practice is open because we're an essential service, and I can tell you that we have undertaken extra steps to protect everyone's safety. We're no longer meeting clients. We are meeting clients via Skype and via FaceTime, and they're signing their documents at home. We actually email their documents to their homes, and that's how we're doing our closings. This month, which is April, we have the same volume of closings as April of last year. That said, real estate is a lagging business. Some of the main questions I get asked about COVID is about residential tenants. So imagine it's the first of the month and your tenant says, can you defer the rent? They don't want to pay rent because they're laid off. So what should you do if you're a landlord? Or what should you do if you're a tenant? Should you let them defer the rents if you're a landlord? Should you deliver an N4 notice that they haven't paid rent and you want the place back? You want to evict them. The problem with evicting them is that you can't get a hearing now because the landlord and tenant tribunal is closed. I would say it's more likely that you should negotiate or take less and defer the balance while the pandemic is on. The whole idea is that we're going to have a reset in the business and everything is going to go back to normal in a few months. And yes, your tenants may owe you a few months rent. There is legislation that has been announced and it's gone into play today where people get some relief. It's not a lot of relief, but in some cases it's better than unemployment. So plan A, let them defer the rents. Yes, that's possible. Plan B, deliver an N4 notice. You can do that too, kick them out, but how is that going to help? That people are just not moving right now during the pandemic. Or negotiate to take less until the pandemic is over and defer the balance. I would probably try number C. D, forgive the rents. Well, good luck with that. I don't think anyone wants to forgive rents. So this is a common story. Another common story is we have a seller here who has already bought a property with a firm deal, and now she's changed her mind about buying because she cannot sell her current home. She says she cannot complete the transaction. No one is coming to view her home because of the pandemic. And as a buyer, she's also asking the seller to give her a break. Is she acting in good faith? Is she trying to fulfill her obligations? So up to now, I would tell you that there is no pandemic relief legislation for buyers and sellers. The buyer does need to close the transaction. There could be pandemic relief clause written into the agreement. A pandemic relief clause would be phrased as a force majeure clause, and a force majeure clause is something that's most commonly used when there's natural disasters or wars, I don't know of anyone who's used the pandemic relief clause. If I was a seller, I would not accept the pandemic relief clause. Basically, force majeure is an intervening act that's beyond the contemplation of either party, and it should delay or cancel the transaction. So in this case, my buyer, who is also a seller, cannot call on any force majeure clause. The other option for her is to claim frustration of contract. So what's frustration of contract? Frustration of contract would be that she would have to claim that it's impossible for her to complete the contract due to unforeseen circumstances. The standard to prove that is very high. It's probably unlikely she would be able to prove frustration of contract. My suggestion to her would be to go and negotiate with the seller to extend the closing date, or even try to get a mutual release if the seller hasn't purchased anything. It's very likely that the seller will refuse, but the case law is that the seller should negotiate in good faith. And if the buyer does claim frustration and force majeure, the buyer will likely have to pay damages to the seller. And a judge usually decides if the buyer was acting in good faith and the seller was acting in good faith to fulfill their obligations under the contract. Of the four options I presented, I like option number D the best because it would allow the buyer to continue to do her purchase if she has enough equity and refinance her old house and turn it into a rental. But this is something she can only decide with a financial advisor. It's clearly not what she intended, but it is an option. She can talk to her mortgage broker, financial advisor, and possibly find that kind of relief. So there is no automatic pandemic relief legislation. Even though we do see a lot of talk about it, there is nothing out there right now. I also hear stories about people worried about the registry office not being open. I will tell you, it's very unlikely the registry office will not be open. The registry office is electronic, so it'll be open all the time during the normal hours. The only thing that I've known to close the registry office is a power outage or a big storm, and that's not a likely event to have happen. I would say that, you know, we worry about putting these clauses in, but a lot of these issues have already been dealt with, and there's a lot of case law, and lawyers seem to follow the case law in dealing with necessary extensions. So if the registry office does close, usually lawyers cooperate. Sellers want to sell and buyers want to buy, and they find a way to cooperate, and they act reasonably and in good faith to continue their deal. So here's another story that I hear very often. You've listed a tenanted property, and the tenant has now refused showings. They say no showings during social distancing. He's advised the seller that he will allow one person to come and do a video walkthrough, and you should sell it by video. What are your options? Is that tenant being reasonable? I think everyone would agree now, because of the fear to health and safety and to one's family, I think the tenant would be acting within their rights to keep you out of the house. I think you should consider doing video walkthroughs and use them to market your property. It is possible that a seller or a landlord can give the tenant an N4 notice of default, interfering with the landlord's rights. If the landlord insists, the tenant can also bring forth human rights complaints against the landlord. But I would say that very few landlords should insist right now. I think that the option of providing safety procedures for showings with a cooperative tenant is possible. So safety procedures could include a lot of different things, including wiping down all surfaces after a showing, having the listing agent present, and so on. That's kind of onerous. I don't really think we'd want to push that. Using a walkthrough, a video walkthrough, and sell the house conditional on inspection is probably the best bet. The final option is take the listing off the market and relist it when things are normal. That's also an option. But I would say if you have to sell, you have to sell, and giving a video showing is better than no showing at all, and make a deal conditional on inspection of the property. That's my favorite solution for that. So this is the fourth pandemic story. So your clients have a restaurant or daycare tenant, and they are required to close during the pandemic. The mayor of the city says, landlords, you have to be nice and cooperate. What does that mean? These are commercial tenants. Does the landlord have to cooperate with commercial tenants? The tenants have stopped paying rent and they ask for a pandemic rent holiday. What options does your client have? So on a commercial tenant, can your landlord lock them out? So usually with a commercial lease, you can lock someone out, and then after you've given notice, your lease will have the notice period. Under the Commercial Tenancies Act, the landlord can not only lock someone out, but they can distrain on their goods. I believe that now that the courts are closed, I think that the tenant may even go and open the door again with their own locksmith. And there's very little a landlord can do. I would suggest it's not a good idea to lock out a tenant during the pandemic, because if a court determined that a landlord was not acting reasonably and in good faith, the landlord probably would have to pay damages to the tenant, even though the tenant hasn't paid the rent. So I do worry about taking drastic measures and locking people out. The other option is negotiate with the tenant, possibly ask the tenant to provide financial proof that they can't afford to pay, and even accept a lesser amount, or defer the balance. That's probably one of the best options. The last option, C, I have heard of landlords give tenants 4 months free rent. That's not always possible. Landlords still have to pay property tax. They still have to pay HST, and they have to pay for insurance for the property. Some municipalities are allowing property tax to be deferred. It doesn't mean that they don't have to pay it. All it means is they'll have to pay the property tax later. So the idea behind these 4 pandemic stories is that, yes, we do have legal rights. We can exercise our rights, but are we acting reasonably and in good faith given the situation at hand? So the guiding principle is reasonability, and that's on the reasonable person standard, and acting in good faith. Once you're in contractual relations, you're not supposed to use the relationship to take advantage of the other party. You do have to give them a break. So I do like the idea of negotiating and giving the other side a break, allowing them to close their transaction.